Hi there. In this video, we are going to be looking at the 1902 orders in council, and then we'll also be looking at the implication that these orders had on constitutionalism. Hello there. My name is Mutiaba Conrad. I'm a lawyer and a private law tutor. And before we start on our class, I encourage you to subscribe to my channel. Just click on the red button in the lower hand side of your screen. Also turn on your notification and also share and like this video with your colleagues so that they are also able to benefit. And then once again, I encourage those students that are interested in private law tutorial sessions, please contact us. We'll be able to make an appointment with you, and we'll give you that extra polish, that extra push that you need. Private tutorial sessions have been proven to work, and most of the students on these engagements have been proven to outperform their colleagues who do not have any sort of mentorship. So please contact us. Our numbers are down in the description box. So let's start directly into our topic today, which is the 1902 orders in council. But before we even go to look to examine the articles in detail, I want to give this discussion context, okay, so that you're able to actually distinguish these so-called orders in council. Now, it's important to note, for you to understand them well, it's important to note that there were actually three types of sets in terms of orders in council. Now, first, there was the 1894 orders in council, okay, which laid the foundation for the signing of the 1900 Uganda Agreement. But there were then also the 1902 orders in council, and that's what we are going to look at. And however, for purposes of understanding this, it's also important to note that there was actually another set of orders in council, that is the orders in council of 1920. Very important to note. So there are three sets of orders in council, and this normally confuses students, but please just put it in context. But for purposes of this class, what we are going to look at are the 1902 orders in council and the implications that actually those had on constitutionalism. So let's start right away by giving context to our discussion. And by way of introduction, what you have to note is that these 1902 orders in council were actually formalized. They actually formalized colonial rule in Uganda, and they were actually the fundamental law of the protectorate. They were more of the main law that actually the conquerors, the colonialists, who were the British, were actually following. And the exercise of the orders in council by the Queen of England were granted by the Foreign Jurisdiction Act of 1890. Please note this, it's really very important, to legislate for foreign territories of the UK. Now, having laid down that background, it's also important to note before we jump into the articles themselves that actually this period from 1902 to around 1920 was actually one of the most despotic unconstitutional and dictatorial times, okay? These were taken to be one of the most despotic and dictatorial times, at least by way of the law, when you examine the law, okay? Because these orders in council were extremely despotic in a way. They violated so many, today, what we call respected international constitutional norms, such as those pertaining to freedoms, to human rights, among others. But just wanted to bring that out very clearly, and you understand that this period between 1902 and up to around 1920, when the second set of orders in council is introduced, which actually makes some amendments and brings in other aspects, which we'll also be looking at, and I encourage you to look at this channel for the 1920 orders in council. There's already a class on this channel, so please look at it. But for purposes of this class, let's proceed now to examine each single article from Article 1 to the last article of the 1902 orders in council, so that we really look at them and we understand actually what these articles are about. And of course, in our discussion, we're also going to be looking at in there the reception clause and also the repugnancy clause. We'll be looking at all these a little bit more in detail. But let's start away with Article 1 of the 1902 orders in council, which actually provided, or rather defined, the provinces, also known as the administrative divisions of the protectorate, and the extent of the applicability of the order in council. Okay, and that article basically lays down the divisions which were the central province. Okay, so this Article 1 actually divides Uganda into various provinces or divisions, and the first one being the Central Division, the second one being the what they call the Rodlof province, then also the Nile province, and then the Western province, and then finally the Kingdom of Uganda. So you realize that actually, even in the division of these various division, or rather provinces, Buganda is actually recognized as a province of its own, because you realize there is the Kingdom of Buganda as a province, but there is also the Central Province. So this is really important to note. And of course, all this comes to show how much, in the eyes of the British, Uganda was influential in a way, and it was very important for them to categorize it as a division of its own self. Let's now proceed to look at Article 4 and 5. When you examine these articles, in essence, they actually provided for the office of the Commissioner as the Queen's representative. You remember when we examined the 1900 Buganda Agreement, it was actually talking about the Commissioners being the representative. So again here, we are seeing Article 4 and 5 going on to provide for that office of the Commissioner as the Queen's representative. Then when you look at Article 7, it provided for the Crown land, and of course was defined, the Crown land was defined as public land vested in it by all treaties, i.e. Buganda, Ankole, Toro agreements controlled by the Queen's representatives. Let's now proceed to look at Article 8 to 10. When you examine Article 8, 9, 10, when you look at them, they actually in essence were providing among others that the Commissioner was to make laws, okay? Although in 1920, important to note, this function was placed in the hands of the Legislative Council. Now, Article 8 to 10 is actually giving the Commissioner power to make laws, okay? And a single individual had powers to make laws. You know, ridiculous as it is, but this was actually true. That's why I was telling you even in my introduction that this period from 1902 to 1920 until the third set of the orders in council are introduced, it's taken to be a period of despotic rule, violation of constitutionalism, among others. It was really a very hard period, especially for law lovers, but even for the citizens of Uganda at the time. Let's now proceed to look at Clause 15, Article 15, Clause 1 of the 1902 Orders in Council. And basically this established the formal court systems as we know them today. That is the High Court, of course, giving it unlimited jurisdiction. And at the time it was styled as His Majesty's High Court of Uganda. That's what it was actually called, His Majesty's High Court of Uganda. It wasn't known as the High Court as it is today. They always added that term, His Majesty's High Court. Of course, this comes to show you how much influence the Queen and Britain had, especially in establishing these court systems, which predominantly are still used intact as they were, of course with some modifications here and there, but predominantly the whole court system as established is still functional up to date. Let's proceed now to examine Article 5, but Clause 2. It's important to note at this juncture that actually this Article 15, Clause 2 is what in law, in constitutional history, we popularly call the reception clause. So every time we talk about the reception clause, we are talking of Article 15, Clause 2, and basically the reception clause is that clause, like the way you're hearing the word reception, meaning it's what brought in the laws, okay, from other jurisdictions, and predominantly most of them are still used today in Uganda, and most of them are actually still intact, others with some amendments and modifications that have been done over the years, but it's basically Article 15, Clause 2 that brings in what we call the reception clause in constitutional history and law. And basically this clause states that the jurisdiction of court shall be exercised in conformity with civil procedure, criminal procedure, and penal codes of India, okay, of India, because most of these laws were copy and paste from India and brought into these other administrative units such as Uganda, Kenya, and other protectorate and colonized countries on the African continent. Now, this introduced most of the key acts used today, such as, for example, the Penal Code, when you look at the Evidence Act, when you look at most of the laws as they are used today, the Judicature Act, and these were made part of the laws in Uganda. So it's this clause that actually goes on to bring all these other laws, most of which are even still used up to date. Let's now proceed to look at Article 20. It's also important to note that Article 20 is a so-called Repugnancy Clause. You have probably heard, or maybe you will hear of the Repugnancy Clause more oftenly in your law school. And basically the Repugnancy Clause and the Reception Clause are very examinable areas, and we like to test you on most of these clauses. I encourage you to look at Article 20, which actually provided that this contained, or rather Article 20 contained the Repugnancy Clause. It basically reorganized the application of native laws that are not repugnant to natural justice and morality. And also important to note is that the Repugnancy Clause was intended to remove those customs and norms that were actually considered negative to natural justice and good conscience. The rationale was good, okay, because there were some customs that were negative, but however, the applicability and the tests that were used is what in many ways became unfair and of course unlawful in a certain degree. And the major problem was that the negative and repugnant aspects of a custom were subjected to what we call the subjective test according to the morals and standards of the Englishman or the English common law principles. As a result of this test, of course, many fundamental customs to the social fabric of the native communities were actually rendered inapplicable at a stroke of the Englishman's pen. Basically, here what we were trying to say is, look, these British brought in what is known as the Repugnancy Clause, and in essence they were saying that any custom, any African custom, the Uganda custom, the customs from Ankole, from Toro, from all the other societies in Uganda, that were inconsistent with what for them in their view and in their eyes they called their English customs, was actually wrong. And this is what we call the subjective test. Basically, the subjective test is looking at the legality of an element in line with what you understand or what you personally see it to be. Okay, so the British were testing our customs that we had lived with for over 400, 600, and 700 years, and they were trying to throw them out as unlawful simply because they didn't understand them, or simply because they were against their common law values. So this Repugnancy Clause, in essence, provided that if any other custom is repugnant with the norms and aspirations of the English people, the same was null and void to the extent of its voidness. Now, there are so many cases around the Repugnancy Clause that were litigated at the time, and I encourage you to look at the Locus Classicus of R versus Amkeyo, a case of 1917, KLR, page 14. But before we go to that, let's first examine the case of Gwao bin Chilimo versus Chisunda bin Ifute, a case of 1928 reported in IT 42, page 403. And basically, Justice Wilson, this was a white man who actually admitted that the test is one of English morals and standards. So we are seeing the judges admitting that the validity of the African values, if we are to choose which one is right, we are going to test it against the aspirations, okay, and the values of the British. Now, this was wrong, okay. Now, the most famous case on the Repugnancy Clause is actually Ara versus Amkeyo, and basically in that case, Justice Hamilton CJ held that customary marriage was not marriage as understood among the English people. Now, this is a very interesting case. I encourage you to go and read the facts. But basically what was happening here, the judge was trying to say that customary marriages, as we know them today, these are values that have lived for so many years. Okay, the Kuhingira, the Kwanjula, okay, the Kuchala, all those, they were trying to say that this whole aspect of customary marriage, having 1, 2, 3, having multiple marriage partners, was not, understood among the English. And as such, because for them, the English, they only understood marriage to mean one man and one wife. But however, in our values, in our customs, actually you can have multiple wives. You can have 2, 3, or 4 wives. So according to the English in this judgment, they were actually trying to say that we don't recognize African marriages as marriages, that the true marriages are the marriages as we understand them for us as whites. Now, this was a subjective test that was being applied by the court, okay, to test our values on what they know. okay? Because, for example, you cannot say that the English style of marriage, or what we call church marriage, which is one man, one wife, is not marriage as known in the African context. And you cannot argue it the other way opposite to say that that type of marriage is wrong because you have one single partner. That is what basically the British were trying to do, turn it around. And we're saying that this Repugnancy Clause actually threw out so many norms and so many values of the African people. Of course, I also encourage you to also look at the case of Muenke versus Megadeth. It's a case of 1933. Again, it proceeds to illustrate the application of the Repugnancy Clause. And basically, in this case, Megadeth wanted to sell Butaka land. Now, among the Baganda, this was actually challenged. The sale of the Butaka land was challenged based on the custom that it was alienable, meaning you could not buy it under the Chiganda customs. You could not buy or sell Butaka land. However, court considered the 1900 Buganda Agreement, specifically Article 15, and the Buganda Land Law of 1908, and held the custom as repugnant, okay, because for them, according to them, any land can be sold, provided there is offer, acceptance, and consideration, there is a contract. But that is not how it is. Among the customs of the Baganda, you could not sell Butaka land. If land is Butaka, you could not sell it. So again, we are seeing the British applying the Repugnancy Clause to declare this custom as unconstitutional and against the 1900 Buganda Agreement and also the Land Law of 1908. So these three cases actually illustrate the Repugnancy Clause at play, and they show you how much that clause affected the values of the African people. Let's now proceed to look at Article 24 and 25. This gave the commissioner powers to make laws for the deportation, which orders were not appealable. Okay, so the commissioner had powers to deport you, and this was not appealable anyway. I encourage you to look at the case of Mukwaba versus Mukubira. It's a case of 1954, and the issue here was whether the withdrawal of the recognition of the Kabaka resulting into his deportation was actually legal. Okay, again, we are seeing these articles being tested. Okay, these articles of the 1902 orders in council being tested later on. Of course, this led to the creation of undesirable natives order of 1907 and the deportation ordinance of 1908. These were to deal with anti-colonial sentiments, i.e. the deportation of members of the Bataka Party. We'll be looking at that later on after the riots of 1940, and of course the Kabaka of Mutesa. The Kabaka Mutesa II in 1953 was also deported basing on this article. Of course, its constitutionality was later on challenged by Bingira in 1956. So Africans started to bring up cases challenging these orders in council. Now, having looked and examined those articles, let's now proceed to look at the implication of the order in council. Those are the orders in council of 1902 on constitutionalism. What implication did they have? Of course, first of all, the first implication is that actually these 1902 orders in council didn't respect separation of powers. Okay, we just went through the orders in council, and you could tell by yourself that actually these orders did not provide for separation of powers. There was no executive, clear executive, an organ. There was no legislative council. Remember, it was the representative of the Queen who would make laws. Okay, there was also no legislature, no executive, no judiciary. Okay, so that respect for separation of powers was very minimum. Okay, and it didn't actually respect that aspect. Let's now proceed to look at the second implication, which actually is that they didn't recognize the rule of law and applied double standards. Okay, of course, this is important. They did not recognize the rule of law because sometimes they were applied and other times they were actually ignored. The other third implication is that they didn't define the rights and freedoms of the individual. We went through those various articles, and you can tell that actually they did not provide for a Bill of Rights. They did not provide for rights of the humans, such as the right to life. They did not provide for the freedom of expression, freedom of movement, the right to freedom from torture. All those rights were not provided for by these 1902 orders in council. Then also number 4, it actually undermined the earlier agreements that were signed by the British, such as the Uganda Agreement, the Ankole Agreement, among others. Okay, it's important to note that actually the British did not only sign the Uganda Agreement, but they also went on to sign the Ankole Agreements, the Toro Agreements, among others. So these 1902 orders in council actually undermined earlier agreements. And the case in point to illustrate this is actually the case of Mukwaba and others versus Mukubira. It's a case of 1954. Go and look at it. And one of the issues in this case was related to the validity of the withdrawal of recognition under Article 6 by the British. Of course, they withdrew the recognition of the Uganda Agreement, and court went on to hold that the withdrawal was an act of state and could not be inquired into its validity. Again, we are seeing here double standards. That's why we noted earlier, because the British withdrew recognition of the agreement. They had a commitment, even in its vagueness and unconstitutional state, they still did not respect it. And you know, when Mukwaba and others tried to sue, and of course that was the holding. Also of the interest here, I encourage you to actually go and read the interesting case of the Katikkiro of Uganda versus the Attorney General. It's a case of 1959, East Africa, page 382. And again, the issue in this case was about the 1953 Buganda Agreement. Okay, 1953. Here we are not talking about the 1900, because there were multiple agreements that actually the British made with Uganda Kingdom. Another agreement was made in 1953, and of course, again, this was not again recognized, and they ended up in court, and court held again that the agreement was an act of state and therefore not challengeable before the courts. Again, we are seeing double application and double standards. Okay, and that's why we are examining to say that, look, there was no rule of law. Okay, this was an agreement that had to be honored, but it was never honored, and court was in a way also applying double standards. So basically that's it, ladies and gentlemen, pertaining to the implication and the orders in council, which has been examined for you in detail. For you, if you've not yet subscribed, I encourage you to subscribe to my channel, turn on the notification, also share this video with your colleagues so that they are able to benefit. And then, very importantly, for students who are interested in private law tutorial sessions, please contact us. Our numbers are down in the description box. We'll be able to help you. We can make private arrangements. Our prices are very friendly, and of course these sessions will really help you to improve your grades in law school. Low grades really matter, and the best grades you have will always increase your chances of success. Thank you very much for following. I will meet in another class. Bye bye.